Let's go to this conversation now. Oscar Pistorius' hopes to be home by Christmas have been dashed. Pistorius was found guilty of shooting his then-girlfriend Reeva Steenkamp. Now, there was some confusion about when exactly did the sentence begin. And let's now speak to legal expert Nthabiseng Dubazana, who, of course, is going to just help us understand some of the issues here. Nthabiseng, thank you so much for your time. The SCA withdrawing the two orders it issued in regard to when the sentence came into effect. In your views, do you agree with some of those who are saying that this is essentially what caused the confusion around his eligibility for parole?
100%. When we look at the original sentence, that was one for murder. It was then in 2013, if I'm not mistaken, and then went on appeal a few times to the SCA. And then as a result, he was then the conviction was then changed from murder to culpable homicide. So now the issue was then, when does the sentence actually start? Does it start at the time when he was convicted for murder, or does it start at the time when it was overturned and then he got convicted for culpable homicide? So when we look at these two different rulings and the situation that happened thereafter, we look at the final ruling that happened, which would effectively be the one that was done in 2014. So therefore, as a result, the eligibility for parole now then would shift to next year instead of this year, if we're to look at the time between 2014 and 2023 that is coming through.
And how do you see this one play out? I mean, there could possibly be two scenarios here, whether to challenge the SCA or at the same time to then focus on possibly the hearing next year. How do you see it play out?
I think they would probably decide to focus on just the hearing, to try and see if they can fast track the parole hearing and all of those things. Looking at what has happened in terms of the SCA decisions, trying to appeal that is going to be unnecessarily costly, because we still have to apply for condemnation because of the times that have passed since the decision was made by the SCA. And the likelihood of the Constitutional Court revoking or overturning the ruling of the SCA is slim to none. That is my opinion, at least. And if they were to overturn it, it may not be in his favor. Just now they go back to the original sentence, which was that of murder, and then the sentence is even increased. This is now in the discretion of the court to do so. So I would suppose, if I was in the shoes of the attorneys, let's not try and pursue that in the event that the sentence is not only increased, but the conviction is not changed from culpable homicide to murder. Let us try and deal with this hearing and see how fast we can fast track that one to bring the hearing closer.
I suppose then, if they choose to focus on the hearing, nothing stops them then from bringing it to light once again next year, March.
Definitely. So in fact, that would be the perfect time to do so and say, right, this is now the official half term, the time for the parole to be heard. Can we now deal with that now? And then they can deal with the internal issues that need to be dealt with in terms of the correctional services. Remember, there's a whole process that has to be followed. The families of the victim have to be contacted so they can understand what's going to happen, whether they are for the fact that the accused is going to be released or not. These interviews have to be conducted in order for parole to be considered. And we also have to look at his time in custody, how he was behaving, whether he has reformed, whether he'll be able to be integrated back into society and all of those things. And if the parole board it does a thumbs up to all of these things that I have mentioned, then he's eligible for parole. But this will be a process that has to start, and the attorney as well as the accused would know and understand that this has to happen.
And he says that he's been a model prisoner, has taken part in all the programs. But let's look at another layer here, the offender-victim dialogue that, the correctional services also talks about here, and he's met, the family as also. How strong is the Steenkamp's voice here?
Very, very strong. I mean, we've had so many matters wherein the dialogue actually breaks down and the family members are not comfortable and happy with the situation where the accused gets released for fear of maybe repeating the same crime again, for fear of that they'll be threatened. But these are obviously dealt with on the merits of each individual case. So in this instance, we would suppose that if the Steenkamps are against it, their reasons, if they are deemed to be reasonable for somebody who is in their situation, and looking at the interest of justice, but also looking at the interest of the accused person. Then the parole board would have to look at all these things in totality and then make an informed decision with regard to that. But their voice is very strong. I believe recently, I think it was earlier this year, if not late last year, one of the accused persons who were dealt with within the apartheid eras, his parole is still being denied till today because the family members are still not comfortable in him being released. So that's how powerful the family's voice is in such situations.
All right, and let's see then what happens next year, March, if they do bring it back, and what the family has to say then on this one. Thank you so much for your analysis tonight, and you know, just really making us understand this succinctly as to what exactly is going on here. Do appreciate it. That was Nthabiseng Dubazana, a legal expert, of course, helping us to understand how we got to this particular point where Oscar Pistorius is concerned.